Welcome to Kanooni Charcha. Today I will discuss a recent Supreme Court judgment having title Rtd Sham versus State of Rajasthan. This is a criminal appeal against the impugned judgment and order dated 27th of September 2023 of High Court of Judicature of Rajasthan at Jodhpur. A prayer was earlier made by the appellants herein for quashing of the FIR, First Information Report, which was lost in the police station Rajgarh of district Chudu, Rajasthan, for commission of offences under section 420. That this is a regarding cheating, and 406. You might be knowing it is related to criminal breach of trust. But despite being made payment of about 1 crore, 11 crores check, and afterwards 89 crores, the party, the executor here, obviously appellants here, it was allegations of the respondents that they are not executing the agreement to sell. The facts also speaks of this case that afterwards they filed a civil suit for specific performance in the a civil court, in a civil court that is pending. But simultaneously, they have got registered a FIR with the police station for commission of these two offences. Quashing of the FIR for these offences, the earlier they have availed the provisions of 482 of Code of Criminal Procedure, but that petition for quashing was dismissed, and present and impugned order has been assailed in this order. Now I will read out I have referred here the facts of the case. Brief facts of the case I have referred. I read here para 6, which is a very important, which relates to how a differentiation is to be made between a civil wrong and a criminal matter. Civil matter, criminal matter. This, as already indicated above, a proof of complaint which has been registered as FIR does not spell out. This is the observation of the Hon'ble Supreme Court of India. In this case, which I am discussing, does not spell out any element or ingredient of cheating or breach of trust. I have already referred that section 405 of Indian Penal Code defines the criminal breach of trust, and 406 provides a punishment for that. This of Indian Penal Code. Mere non-performance of an agreement to sell. This is a civil nature matter. Agreement to sell by itself does not amount to teaching, and breach of trust. How offence of breaching and this breach of trust could have been committed. Now again, there is a mere non-performance agreement to sell by does not amount to cheating and breach of trust. Respondent number 2 has adequate remedy of filing of the suit. Filing of there is observation of the Lordship that they have a remedy to file a suit for specific performance, which they have already availed. The FIR only appears to be an arm twisting mechanism. This is a coercive method in order to compel the respondents to execute the formal sale deed. But law has to take its own course. How FIR can be now lodged in such a matter or particular with regard to cheating a criminal. Now, the section 420 has been referred here and defined. The definition of section 420 is reproduced here. I have already said that section 420 relates to punishment. Section 415 of Indian Penal Code deals with the definition of the. We are first concerned by the ingredients of cheating are made out. Whether I may for this section, cheating as defined under section 41 of Indian Penal Code, there should be a fraudulent or dishonest inducement of a person. There was a mens rea at the very beginning, when this execution of the agreement to sell was done, when this agreement was arrived between the parties, and it must the prosecution the complainant has to work out. Whosoever put an allegation of cheating, he must work out. He must prove that there was this cheating element, there was a fraudulent element, ingredients, this inducement, this element at the very beginning of the entering into such an agreement. But they have referred the person cheated must be dishonestly induced to deliver property to any person. So now they have found. Now similarly they have referred section 405 and 406 for convenience of this judgment, for convenience of the whosoever reads this judgment. Now, para 12 is an important. They have appreciated what they have, how they have appreciated. In the present case, the appellants were not entrusted with any property by respondent number 2, complainant. कोई property तो नहीं दी थी. Simple an agreement arrangement was made as to further sale. Agreement was there, but again payment is still balanced. Of payment was there at the time of execution, and a promise was made, an agreement was made. The only delivery made was part of the payment towards the agreement to sell between the parties. There was not a complete payment. The amount paid towards consideration cannot be said to have been entrusted with the appellant. Oh, now they have taken, they were about to work out by the offence of criminal breach of trust is made. They have said that there was no any entrustment of any property. Additionally, merely because the appellants are refusing to register them, only element, only allegation, only this you can say the fact involved, the allegation involved, which led to registering of a was, but merely a refusal on the part of the respondent to execute formal sale deed in favor of the appellant. This was the cause, reason for lodging of FIR according to, since there was no entrustment of property which is required in a criminal breach of trust. The offence of misappropriation of such property and thereby criminal breach of trust cannot be said to be made out. They have talked about the section 420, and they have said that no element of cheating is fraud or this cheating is involved, and similarly there is no entrustment of this any property which can said that on the basis of which it can be said that there is a criminal breach of trust. Therefore, para 13 is very relevant. Therefore, the ingredients of none of the offences alleged in FIR made out against the appellant, and thus no offence can be said to have been committed by them. So, if from the allegations, from the FIR, it is found that no offence is made, particularly offences alleged 406 and 420. Now again they have gone further. The act act of appellant at the best constitute civil wrong. They have said that civil wrong have been camouflaged as a criminal wrong. The act of appellant at the best constitutes a civil wrong and does not call for any criminal action as is done in present case against them. A civil wrong cannot be given a criminal color merely to coerce the appellant in resisting the sale deed. This I have verbally already made it clear that the only intention of lodging of FIR, modus operandi adopted by for lodging of FIR was to coerce, to compel to the respondents to lodge FIR, not respondent but to appellant, because against whom FIR was lodged, this to compel them to execute this was being done by the respondent. The judicial process cannot be used as a tool to enforce specific performance of an agreement to. Now, this judicial process of such kind of judicial process for lodging of FIR, where suit for specific performance according to settled position of law, according to statutory provisions of law, is available, then respondent number 2 has ample remedies under the civil law, and he has already resorted to the same by filing a civil suit. This I have already mentioned and told you that the suit of specific performance was already filed by the respondent number 2 before the competent court of law. Accordingly, appeal is allowed. The impugned judgment and order is satisfied. Impugned judgment and order of the Hon'ble High Court of Judicated Rajasthan at Jodhpur, which was the order and judgment was passed in a petition filed under section 482 of the Code of Criminal Procedure by the appellant here. We make it clear that any observation made in this order will not come in the way of civil court in deciding the suit, which shall be decided on its own merits. This clarification, the best of evidence led during the trial. FIR was quashed. What type of matters you will find in these courts, in law courts? Generally speaking, the client is in very hurry, and our advocates are very comfortable for this whatsoever the client wants, how the client wants. Accordingly, the matters are dealt with, the petitions are drafted, FIRs lodged. But I say here that magistrate, if direction is sought from the magistrate for lodging of FIR, now this whole game has been changed with the coming into operation of the BNSS new Code of Criminal Procedure, you may say, Bharatiya Nagrik Suraksha Sanhita, in which ordinarily FIR is not to be registered, or particularly in such cases, not at its own by the police officer in charge of police station, not at the direction of the Hon'ble court with magistrate. We have already discussed these provisions, and I have already an episode upon this, how an FIR is to be registered and at its own by the police and on the direction of the magistrate, a magistrate. But the police officer or the magistrate who registered the FIR or on whose direction we must be careful now. And in particular in such type of cases where the civil wrong is involved and it has being camouflaged as criminal wrong, criminal offence, or gone to the cheating. How, if you will see how stringent punishment is provided in these two offences, or a long trial If somebody is put to trial, after the investigation, and the charge sheet is there, a long, the one has to face a long trial before a competent court of law by a magistrate. I think it is sufficient for today. Thank you. Thank you very much.